Hello friends, welcome R.Ranjan IAS and PCJ and Passion IAS. In this forum, we are going to discuss various affairs of political, economic and social nature. Today, we have picked up the topic of Maharashtra imbroglio. The political situation in Maharashtra, which is none of our interest so far as our Union Public Service Commission examination is concerned. But some constitutional provisions have been invoked recently, and that is why it becomes important for us to discuss what these provisions are and how these provisions are being understood by the people on various fora like WhatsApp groups, Twitter, etc. What I have noticed that there is a lot of rumor, grapevine communication, a lot of confusion regarding this, that whether what has happened in Maharashtra, the imposition of President's rule, is justified or not justified. And for that purpose, we have to see Article 356 of the Constitution, Article 355 of the Constitution, and Article 357 as well. And then we will see some parallel situations that have occurred in the past. Right? A very similar situation had occurred in the state of Bihar also a few years ago, and that was brought before the Supreme Court in Rameshwar Prasad versus Union of India case. So we are going to see the situation of that case, and we are also going to see the landmark judgments like S.R. Bommai and Rameshwar Prasad. These two cases will be enough to answer the present question, that whether imposition of President's rule in Maharashtra is justified, is constitutionally valid or not. Though the question is sub judice, the matter has been brought before the court. But before we go into the practical aspects, let's see what the theory says. So far as Article 356 is concerned, introduction. In the words of Dr. Ambedkar, such articles will never be called into operation and that they would remain a dead letter. Interestingly and very ironically, Dr. Ambedkar believed that Article 356 would rarely be invoked, or rather would never be invoked. He said that it would remain a dead letter in the Constitution. In fact, some of our members of the Constituent Assembly were not ready for this provision. They raised an objection that Article 356 would make the states subordinate to the center, and that is why they were not in favor. But in spite of the opposition, Article 356 was incorporated in the Indian Constitution, and Dr. Ambedkar was very optimistic that this Article 356 would never be used. Unfortunately, this has been used for more than 120 times, and rather, most of the times it has been abused. It won't be bad to say that it has been abused rather. It has been used as a weapon for political vendetta, for political revenge, especially when the ruling party at the center was different from the ruling party at the state, and some political conflict occurred, because of which a punishment was given to the state government as well as to the state legislature. Sakaria Commission had also examined 75 cases of President's rule from 1951 to 1987 and found that 52 cases out of 75, Article 356 has been used not meant for. Not meant for means Article 356 was used for a purpose ultra vires the Constitution. Means the Constitution has given this power to the central government, to the union government, for performing a duty mentioned in Article 355. If you would see Article 355 of the Constitution of India, you would notice that it says, "It shall be the duty of the union to protect the state from external aggression, war, internal disturbance, and to ensure that the government of the state is carried on in accordance with the provisions of the Constitution." So you see that Article 355 gives 4 duties to the union. Duty number 1, protect the state from war, protect the state from external aggression, protect the state from internal disturbance. That internal disturbance can be of any kind. It can be political disturbance, it can be a social disturbance. And the 4th duty, that the government, the union government, has to ensure that the government of the state is carried on in accordance with the provisions of the Constitution. So what provisions? all the provisions that are related to the state as well as to the union-state relations. For example, we have certain provisions related to state in the Indian Constitution. If the government of the state is not working according to those provisions, then Article 356 can be invoked and precedent rule can be imposed. Similarly, there are provisions related to directions given by the union executive to the state executive, that you will see in the union-state legislative relations as well as union-state executive relations. In that you will notice that the union government, the union executive has the power to give directions to the state executive, and if the state executive does not comply with those directions, then 365 says non-compliance with the directions would amount to failure of constitutional machinery in the state. In other words, the government of the state is not being carried on in accordance with the provisions of the Constitution. So, it doesn't matter whether the non-compliance or violation of the provision of the Constitution is adequate or inadequate, is major or minor. What matters is whether it is relevant or not, whether it is violation or not. If it is violation, then it shall be the duty of the union to bring the state back onto the track, the constitutional track, and to maintain constitutionalism within the state. So, Sarkaria Commission has especially pointed out, and this was pointed out in the SM Mumbai case also, that when the union has to perform its duty, a sublime duty under Article 355, and then if that duty cannot be performed without taking recourse to Article 356, then it may invoke Article 356. So Article 356 comes after 355. So Article 356 has an aim, has an objective. The objective is that the union has to protect the state, because the union is more resourceful. The union has advisory bodies like the Niti Aayog, national commissions are there. It has greater expertise. It has more resources. Therefore, the union has been given the duty to protect. It is an example of cooperative federalism. Article 355 read with Article 356 very clearly lays down before us that the scheme of the Constitution is cooperative federalism. And this is what Glanville Austin, a great constitutional scholar, has also pointed out about the Indian Constitution, that it is cooperative federalism. So what should be the purpose of Article 356? It should be to cooperate with the state. In what respect? Cooperation in the field of protection, cooperation in the field of provisions of Constitution to be complied with, and therefore Article 356 has been there in the Constitution since the very beginning. You will see under Article 356 clause 1, if the President on the receipt of report from Governor of a state or otherwise, so here the key words are report of the Governor or otherwise. Otherwise means report from any other source or information from any other source can also be the basis of invocation of Article 356. So either there has to be a report from the Governor, or it can be a report from any other institution, body, government, like Council of Ministers. It can be a report from an officer of the President. It can be a report from anywhere else. Right, any source. The source has not been identified here. It means any other authentic source upon which reliance can be placed. So, under Article 356, first of all, condition that the President receives report from the Governor or from any other source. And what does the report state? What is the content in the report? The content in the report is that a situation has arisen. You can see present perfect tense. Means it is not a threat. It is not a possibility that something will occur in future. A situation has already arisen. And what kind of situation has arisen? That the government of the state cannot be carried on in accordance with the provisions of the Constitution. So if it appears from the report that the situation has arisen, that the government of the state cannot be carried on in accordance with the provisions of the Constitution, I will read out some of the situations that can be considered to be this situation. That a situation has arisen, that the government of the state cannot be carried on in accordance with the constitutional provisions. So what situations are these? Any provision of the constitution is being violated, or the state government is not willing to act according to the provisions of the constitution, or lacks resources, or it is unable because of any other reason to handle the situation, and therefore it cannot be carried on in accordance with the provisions of the constitution. For example, suppose elections have taken place, but it is a fractured verdict, so no single party has got the majority. As a result, government cannot be formed for several days. In such a situation, there has to be a government in the state, and let's say the caretaker government that had been taking care of the situation till now has already resigned. So it's a headless state. There is no minister, there is no chief minister. Then what would happen? The legislature has already been put in place, it has been elected, but a government cannot be formed. So in such a situation, somebody has to run the government, somebody has to take care of administration, or otherwise there will be anarchy, there will be lawlessness. So this is also a situation where we can say that the government cannot be carried on in accordance with the provisions of the constitution because the government cannot be formed. So the government has not been formed, and therefore it cannot be carried on. So what happens when this situation has arisen? If it appears to the union government that the state cannot handle the situation, and there is a failure of constitutional machinery, or you can say breakdown of constitutional machinery, then the President, on the advice of the Council of Ministers, it must be noted here that Article 74 applies. This is an executive decision of the President, hence Article 74 applies. The President is bound by the aid and advice of the Council of Ministers. So when the Council of Ministers advises him, he will read out the proclamation that President rule is being imposed on the state. And what are the consequences of this? First, assume to himself all or any of the functions of the government, means the President will take over all the functions of the state government. So whatever the Chief Minister and the Council of Ministers of the state were performing or would perform would now be performed by the President. Then all or any of the powers vested in the governor or any body or authority in the state other than the legislature of the state. So what the President cannot take over in this clause is the powers and functions of the state legislature. Otherwise, he can take over or she can take over all the powers and functions of the state government, of the ministers, of the local bodies also, of the government departments, every authority, including the governor. Though practically it is through the governor that he exercises these powers, but he can take over the powers of the governor also. The President can declare that the powers of the legislature of the state shall be exercisable by or under the authority of the Parliament. So this clause suggests that once Article 356 has been invoked, the President may declare that the powers of the state legislature, functions of the state legislature would now be performed either by the Parliament, or the Parliament may delegate this authority of legislation to anybody. So obviously the Parliament can do so by making a law only. The Parliament may start exercising the powers of the state legislature, which means the subjects of the state legislature would become the subjects of the Parliament. The Parliament would have jurisdiction over the subjects of the state legislature. We all know that the powers between the state and the union have been divided, and usually in normal circumstances the subjects of the state list are within the exclusive jurisdiction of the state. So the union parliament cannot make laws on those subjects, but this is an extraordinary situation. In this situation, the invocation of Article 356 has empowered the Parliament to exercise the powers of the state legislature also, and if the Parliament delegates this authority of legislation to any other authority, then that authority will have the powers and functions of the state legislature during the term of emergency. Then the President may make incidental and consequential provisions that he thinks necessary, means he can make other provisions also that must be made for the purpose of making this invocation successful. Right, so necessary or desirable for giving effect to the objects of the proclamation. The President may make provisions such as suspending in whole or part the operation of any provisions relating to any body or authority in the state. So the President can even suspend a body, can take over the powers and functions of that body in part or in whole. It can make suspension orders also, that so far as the period of emergency is concerned, means I am talking about this President's rule. This is an emergency situation. Here the President may suspend some authority also, some body of the state also, and take over the functions of that authority or the body. The proviso to Article 356(1) rules that the assumption of the powers of High Court means the President cannot take over the powers of the judiciary. Obviously, India has an independent and impartial judiciary. That is a basic feature of the Constitution. So in any situation, the President cannot take over the powers of the judiciary. All he can do is to take over the powers of the executive and make a declaration that the powers of the legislature will be taken over by the parliament. The power under Article 356 is an emergency provision, but it is not an absolute power. Yes, it's not an absolute power because conditions are attached. We have just now seen one condition is that there must be a report by the governor or report by some other source, or some material information has been received from some source, means some report or some reliable information must be there. It cannot be done at the whims and fancies of the President of the Council of Ministers or at the pleasure of the President. Here, it is required that the conditions that we read above must be fulfilled. So first condition is there must be a report or material information from a reliable source. Second condition, the report or the information indicates that the situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. Now, on the receipt of report from governor or otherwise, we have already understood this. The expression otherwise means that the President may act on the information received from sources other than the governor. A situation has arisen shows it is in present perfect tense. It means it must be a real situation. It cannot be just a possibility, an apprehension, a conjecture, a surmise. No, it has to be a real situation, that a situation has arisen. Now the question arises whether the power exercised by the President under Article 356 can be judicially reviewed or not. Obviously, the President cannot be personally questioned for whatever he has done in his official capacity. But so far as his decision is concerned, that can be challenged in the court if it is violating of fundamental rights or if it is violating of the basic features of the Constitution. So in S.R. Bommai case, which is a landmark case in this regard, the President acting under Article 356 had promulgated President's rule in 6 states between 1989 and 1992, and all these decisions of the President were challenged at different times and they were heard together by the Supreme Court in S.R. Bommai case. So S.R. Bommai case was not just case of one state, it was a case of 6 states clubbed together. In unanimous opinion, with K. Ramaswamy partly dissenting, the court laid down the following propositions. The first one was that the proclamation has been made upon a consideration which is wholly extraneous or irrelevant to the purpose for which the power under Article 356 had been conferred by the Constitution, namely a breakdown of the constitutional machinery in a state or where there is no reasonable nexus between the reasons disclosed and the satisfaction of the President, because in such a case it can be said that there has been no satisfaction of the President, which is a condition for exercise of the power under Article 356. Now, in this paragraph, some questions that are not given here need to be discussed. Like when this question was put up before the Supreme Court, that whether the proclamation of President's rule was constitutional or unconstitutional. The Supreme Court said, number one, what advice was given by the Council of Ministers to the President is beyond our jurisdiction to examine. Obviously, because it is given in Article 74 itself. Article 74 bars the jurisdiction of the court from the advice given by the Council of Ministers to the President. Means the courts cannot ask what advice was given. The court cannot ask all the things that constituted the advice document. The court cannot ask all the suggestions and the recommendations. What's the reason behind this? We know that the Council of Ministers means all the ministers are the subordinate officers of the President. And when they take oath of confidentiality also. Now this is an official communication between a subordinate and his superior, the head of the Union Executive. It is of confidential nature and therefore it cannot be inquired into by the court of law. True. So here in SR Mumbai case, the judiciary very cleverly held that we will not ask what advice was given, but we can ask you to produce before us the materials on the basis of which the advice was given. Okay, don't tell us what advice was given, but what materials were there? What reports were there? What information was there? Because that is the requirement given in Article 356. And since it is written down there expressly, we can ask for these because that is a condition. So it's not an absolute power, it's a conditional power. And we will examine whether the condition is satisfied or not. It must be remembered that judicial review is also a basic feature of the Constitution. It's an inherent power of the constitutional courts, high courts and Supreme Court. And therefore, the judicial review cannot be barred unless the Constitution itself has expressly barred it. So here, in Article 74, see how clever the Supreme Court was. Means what a clever mechanism was devised. That we will not ask the advice, what advice was given, but we will ask on what basis the advice was given, on what materials the advice was given, on what report the advice was given. Why? Because this is expressly mentioned in Article 356 and this is the condition mentioned there. The moment the Constitution makes a condition express, we can examine it. Because the Constitution has not barred us from examining the report of the governor, from examining other resources of the governor. We have been barred from examining the exact advice that was given by the Council of Ministers to the President. So, here, in a very clever way, the Supreme Court entered into the arena which was indirectly prohibited for the court under Article 74. But anyway, this was done for justice. Now, in this, one more thing was held, that we will not see whether the ground on which the precedent rule was imposed was adequate or inadequate, whether it was a major ground or it was a minor ground. It can be a very slight, very flimsy ground also, but it must be noted that we will see whether it was relevant or not. Relevant means whether it amounted to violation of the provisions of the Constitution or not. We will continue the discussion in the next part of the lecture.